Gulati. I'm head of Joshi Advocates. Thank you very much for joining us in this video. In the next 5 minutes, we'll look at EU settlement scheme application rejections and what to do if you are rejected. So 1. EU settlement scheme applications are being rejected from 9th of August 2023 because the Home Office policy is saying the deadline was June 2021 for the EU settlement scheme application. Why are you applying 2.5 years later in 2023? And what is the reason, and provide the supporting documents. Now, let's say you provide the reason for delay, for instance, a medical condition or a lack of a valid ID because your embassy is not in England and you had to do many other things to get the valid passport in England for yourself. These are some of the reasons. But even though you provide these reasons and the documents from official sources, Home Office has discretion, has the power 50-50 to accept with the documents and reasons whether they would accept your application as valid or reject it as invalid because it's significantly out of time and there's no reasonable explanation with supporting documents, right? When the Home Office rejects the application, there is no certificate of application, COA, issued, which means there's no right to work permit or right to live in the UK. That letter isn't given by the Home Office in the email, right, for the EU settlement scheme application. And when it's rejected, Home Office decision does not carry a right of appeal, does not carry admin review. A rejection simply, your application was not valid. So step 1 is to submit the application with a reason and supporting documents, and sometimes it's helpful to do a supporting letter. My name is this, I did not submit the application at this time because of ABCD, go in timeline order, and here are the documents from the hospital or XYZ why I could not apply in time, right? Now, say the Home Office still refuses the application, say the Home Office still rejects the application, what can you do about it? Now, you may consider doing a pre-action protocol letter. That is a formal notice to the Home Office saying, look at my application documents again. And another casework department looks at it and sees whether a reasonable assessment was made as to whether your application should be valid or not because it's out of time, and whether you've given documents supporting the explanation that you're relying on why the application is out of time, right? So you would benefit from another caseworker looking at your application and documents, and possibly Home Office could consider your application as valid, and then the EU settlement scheme application would continue. Now, worst case scenario, still the pre-action protocol response from the Home Office is like, no, we have discretion to reject your application because we're not satisfied with ABC explanation or ABCD documents. Then consider whether to submit a fresh EU settlement scheme application addressing the concerns raised by the Home Office with supporting documents. Worst case scenario, you may take legal advice on this before you issue judicial review. A judicial review is a formal application in the court challenging the Home Office decision on the legal validity, saying that the Home Office decision is unlawful, disproportionate, unreasonable. But keeping in mind, Home Office has discretion. They have the power 50-50. Whether they exercise that power in your favor or not is another matter. But be very careful and take legal advice before you pursue judicial review, because not only does it carry a cost implication, which means if you lose the case, you have to end up paying the Home Office lawyer's fee and the cost related to that. And look at the merits of the case before you pump money into that aspect, right? Now, as always, I hope that's been helpful. Contact me, details below, subscribe, and I'll see you next week. Thank you so much. Take care.